Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the losses of Rajiv S. Khanna PC. Today is August 25th, 2016. This is our community conference call we host every other Thursday. Everybody's welcome to call or Skype. As you would have heard when you logged in, calling into this or posting a message here does not create an attorney-client relationship, and this is not a substitute for a one-on-one consultation. Let's go over the frequently asked questions first. As we go along, I will explain to you how we do these calls. First, we'll do the frequently asked questions, then any follow-ups on those frequently asked questions, and then we'll do other posted questions, and finally, if time permits, new questions. The first frequently asked question is currently doing my MBA. I'm finishing my school on September 4th. OPT has been applied for in August. So we have a timely filed OPT. Now the 60 days grace period will begin after the school ends. So the question is this: I've also applied for an H-1B. Would I be out of status if I get neither the H-1B approval nor the OPT approval before the 60-day grace period ends? And the answer is I don't believe so. In my view, a timely filed OPT application prevents you from being out of status. To the best of my knowledge, that's the way it would work. Okay. Anybody has a follow-up question on this? Press *5 on your phone. No new questions. *5 on a follow-up question. Okay. Next question is also, it's a very short and brief question, but it's a frequently asked question. What is required for documentation of an EB2 sponsorship for a future position? First of all, if we are talking about filing a perm application for a future position, there's really no documentation required other than the employer's consent, whether it be oral or written, to process the paperwork. And of course, they have to pay for part of the fees. But there is no specific documentation required to begin the process. Along the process, you will need different things, including the company's tax returns and, of course, their ongoing intention to hire you. But you don't really need anything specific. The employer has to cooperate with the lawyer. They have to provide salary, job duties, all those things. And eventually, they will need to provide also the tax returns of the company, usually for the years that the green card was pending. So it's not simply a matter of a job offer being sufficient. There can be a whole lot of other things that are required. Above all, companies' ongoing desire to continue with the application. Are there any follow-up questions? Press *5. Okay. Any follow-up questions? Nothing new yet. We'll just do the follow-up questions first. Okay. Then we go on to the next frequently asked question, if there is one. Yes, there is another one. Green card holders staying outside the USA for less than 12 months. Well, this has been discussed many, many times before. I have discussed it in our frequently asked questions. See, people have this misconception that if you have a green card approval, you can stay outside USA for less than 12 months and you are immune from any challenge to your green card. That's not true. The law is, if you are outside USA for 12 months or 1 year, you have lost your green card. Unless you can convince the consulate that your absence from the United States was because of circumstances beyond your control, and that when you left the USA last time, you intended to return within a short period of time. If you cannot do that, your green card is gone. So 12 months or 1 year, if you've been outside the United States, the green card is automatically gone unless you can present to the consulate evidence to the contrary. What we are talking about here is something called SB1 or returning resident permit. SB1 visa, and those are difficult to get. Now, if you leave United States after getting a green card, even for 10 days or even for 1 day, not intending to return back. Technically, your green card can be taken away by the government. So don't think that being absent for 12 months is the only way you will lose your green card. You can lose your green card by a combination of your intention and your leaving. That said, in this case, what has happened is that parents had obtained green card. They left in August 2014, returned back Feb 2015, and left again on September 30th, 2015. So they've been gone since September 30th. So this September 30th will be 1 year. They've had some health reasons. They had to attend to grandmother who fell ill, etc., property issues, etc. That would become a question of proof then. If they're outside USA for 1 year, that would become a problem. Now they are planning to return on September 18th. Less than 12 months is not an automatic cancellation of the green card. Don't worry about them coming back, because if they're coming back within a year, even though it is 11 months and almost 12 days or 18 days, let them come. Be prepared to answer at the airport questions about why the trip was so long. Bring whatever evidence you think would show the reasons for being outside. The rule is, if somebody shows up at the airport with a green card in possession, government has to let them in. They can, of course, confiscate the green card and ask them to appear before an immigration judge, where eventually over the next year, 2 years, you will have to convince the judge that, one, when you left the United States, you left with an intention to return rather quickly. Circumstances developed that you couldn't do that, and that you never had the intention to relinquish your green card. So coming in, I think, will be okay. Is there a legal issue on staying in India for more than 180 days? No, what happens is, if you're outside USA for less than 180 days, then your chances of getting questioned extensively are relatively small, because there are some technical reasons it's not considered to be a re-entry. I forgot what they call it. It's not considered a readmission, something like that. But the idea is, if it is less than 180 days, less than 6 months, you are not likely to be questioned too much. Is there anything called the 11-month rule? There is no such rule. What do they need to do to avoid any legal issues and face no issues with the green card? I don't think you can do either. I don't think you can avoid legal issues, because you have been gone for a long time, and I don't think you can face no issues. That is just not possible. So one more thing I want to add here is that in circumstances like these, the worst case scenario, even if they lose their green card, you can reapply again. It isn't like this is once you lose your green card, you can't apply for it again. If you are a US citizen, you can apply for your parents as many times as you need to. Any follow-up questions on this? *5. Any follow-up questions? *5. Nothing new? Follow-up questions. Okay, let's get started with the other posted questions. This is from Katraj. Wife is on H-1B, applying for H-4 EAD. Is it mandatory that I need to approach my employer? Not at all. Not at all. Your wife's H-4 EAD can be done through any lawyer of your choice or through yourself. What would be the time frame? Nobody can really predict that. We've had cases approved in weeks, and we've had cases approved in months. There is no premium processing for H-4 and H-4 EAD. Is it difficult to get her back on H-1B? No, not at all. If you have a job and she qualifies, you can get her back on H-1, no problem. Any follow-up questions on what I just discussed? Press *5. Any follow-up questions? *5. Okay. Also from Katraj, I-140, Previous employer filed my green card in EB3. The priority date is 2009. New employer filed in EB2. They did not port my priority date. Well, priority date porting is automatic. You don't have to do anything. Government is supposed to automatically assign to you the earliest priority date to which you are entitled. Do I lose my priority date in any circumstances, like if the old employer revokes my I-140? Well, current thinking of the government is you lose your priority date under two circumstances: if the I-140 was approved in error in the first place, or two, if government revokes it for fraud or misrepresentation. A third circumstance, which is not very clearly defined, could be when and if the employer goes bankrupt. Can they then revoke the I-140? And the answer is yes. Will they take away the priority date? Probably not. Priority date revocation appears to be under two circumstances currently. I don't know what tomorrow brings. One, if the I-140 is revoked for fraud or misrepresentation, or if government for some reason believes that the I-140 was approved by mistake in the first place. Okay, star 5 if you have a follow-up question on this, star 5. Next question is talk to Merrick, sorry, Ricky. Ricky says, I'm on L1A expiring April 2017, maxing out 7 years. My company will most likely file my green card if EB1 becomes current. My wife is also on H-1B. If the dates do not become current, can my green card be filed and I can stay beyond 7 years? No. On H-4, I'm sorry, yeah, you can. You can convert to H-4. H-4 is not subject to those 7-year limits. So you can be with your family, convert to H-4. That is not a problem at all. Star 5 if there's a follow-up question, star 5. Okay. Next question is Manu. Moving back to India with an approved, oh, there is a question. Illinois, go ahead. Illinois, you had a question?
Yeah. So basically, let's say if EB1 becomes current in October, and if my green card is filed, do you think it is sufficient time between October 2016 and April 2017 to get the green card, or can I stay on I-140 if it is approved?
You can't stay on I-140, but if the priority date is current, your lawyers will most likely file I-140 and 485 together. If the 485 is properly filed, you can stay as long as the 485 is pending, no problem. And you'll also get employment authorization if you apply for it, and you'll also get advance parole to travel if you like.
So basically, I-140 and 485 need to be filed together.
If the priority dates are current, that's what should be done. That's the smart thing to do. Yes, absolutely.
Okay. Thank you.
You're welcome. Good luck. Okay, let's go on to the next question. Oh, I just finished that. That was Ricky. So Manu is moving to USA with moving to India, sorry, with an approved I-140 and wants to go for consular processing once dates become current. I've been told by my employer that when I-140 was filed, they selected an option for consular processing. Yeah, you want to figure out how to know whether consular processing was selected. Just look at the I-140. Get a copy of the form I-140, and there's a particular checkbox there. Look into the checkbox. I'm also, by the way, guys, I'm monitoring my tweets if somebody is tweeting to me. Okay. So yeah, you can just go ahead and look at the form I-140 itself. If they have selected consular processing on the form I-140, an I-824 is not necessary. By the way, Manu, make sure your employer has the ability to pay wages if you are not on their payroll, and make sure there are no other issues in moving to India and casting doubt upon the continuity of your green card. I strongly recommend you have a detailed consultation with your lawyers. Okay. Star 5 if you have a follow-up question, star 5. Okay, next question is from Richa. She's got her US citizenship 2016, applied for I-130 for father and mother in Feb. Mother's petition approved, currently consular processing. RFE on father's petition, proof of relationship. Okay, so this is beyond merely, so what they want is to ensure that your father was indeed acting as your father in supporting you. Okay. Uh, So what you have arranged is secondary school leaving certificate which shows father's name, old Indian passport which shows father's name, declaration from school that he was paying for your boarding, lodging, etc., affidavits from mother and two blood relatives. I think that should be sufficient. You can also provide some pictures, family pictures where your father appears. You can also, maybe on the ration card, there might be his name along with yours. You can also, anything else, for instance, ongoing conversations with your father if you called him. I've never had this RFE, this particular question from Indian nationals. I've had it come out in the context of other nationalities, but never for Indian nationals. So it's a little surprising. Nevertheless, I think you're going along the right lines. Would this work? I don't know, but provide as many items as you can. You may want to put your affidavit in there too. Okay. Star 5 if there's a follow up question on this. Star 5. Okay, next one is from Swap K. Well, looks like we are pretty much halfway there almost. So we are flying through the questions today, which is good. Masters in US 2011, worked on OPT CPT on H-1B with the current employer. H-1B filed with higher level SOD. I'm not sure what SOD is, architect. Whereas I work as network specialist through salary, those salary matches to SOD. Can SOD? I don't know what SOD is. Are you on the phone? Press star 5. Swap star 5. I don't know what SOD means. I've never heard this expression. 1 second. You're here. Help me understand this. California, help me under.
Hello.
What is
Yeah,
SOD? What is it?
it shows in the my LC or like LCA. There's a title for my job title when we filed the LC or LCA. I think
SO.
it's I don't remember the full form of this.
I'm trying to see. I don't even know what SOD. Never heard about SOD. Huh.
It's associated with the number, like a number for the when we file the job title. Like it's if it is software developer or the architect or the manager, it's different number or different SOD for different job.
SOD. Are you saying SOC instead of D?
Uh, Maybe it's like I also heard that first time.
It could be SOC number. But anyhow, the bottom line is this. Let's forget about this SOD, SOC. You said your H-1B was filed as an architect, right? Isn't that what you said?
Yes.
Well, first of
Yeah.
all, what you need to do is please have a conversation with your lawyers. That's one issue I saw. Make sure your
Okay.
H1 and your actual job descriptions are the same. You can't have those kind of discrepancies that can be considered to be fraud by the government. Okay, so make sure that this is corrected. I'm not that worried about green card as long as there are no misrepresentations in the green card application, but I am concerned about this being a problem for your H1. Okay.
Yeah. Okay. Sure. Thank you.
Okay, now as far as counting the experience with the same company, that is definitely possible. How is that possible? If your job is more than 50% different. I'll give you an example. Let's say you are working as a network specialist, which you are, right? So your job is
Yeah.
basically setting up firewalls, setting up routers, doing intrusion checks, monitoring the network, I don't know what level work you do. Let's say you're monitoring the packets. You're, basically doing network engineer's job. What if we were to offer you a job as a network architect or network engineer or network planner when you get your green card? And that job description is to review the needs of a client, to decide how many nodes there are, what kind of network, what kind of routers will they need, what kind of connectivity they will need, and then you supervise the people who actually implement the network. So that's a higher job. Now you can use the experience gained with the same employer. So it is possible, definitely, under the law. You clear?
Yeah, okay. Yeah,
Okay.
thank you.
Yeah, if the law says if the job is more than 50% different, you can use the experience gained with the same employer. You can continue working as a network specialist till your green card comes, and that could be several years down the line. Then the employer must have the intention to promote you to that higher title. Make sense? No.
Yes, yeah, okay.
Good.
Thank you.
Well, good luck to you, sir. Okay, let's go on to the next one. This one is from Ram. Third H-1B extension after my EB2 I-140 approval. Priority date is 2010. Okay, employer got acquired by another company. I may be laid off. I have an offer from another company, but they will start after 2 years. Well, the good thing with you is you've got your priority date already locked up, which is 2010. So as long as you don't lose that, which you shouldn't, even if the green card is started a couple of years later, it doesn't really hurt you. It doesn't really hurt you. But it makes me nervous not to have a green card started for as much as 2 years and just sit on it. Another problem is if the old employer revokes the I-140, your right to get H-1 extensions goes away. And you can, Ram, you can change employers as many times as you like without having to worry about your priority date. Priority date becomes personal to you. If you change 20 employers and you've utilized that priority date for 7 employers, you still have 13 more employers or any number of employers you can use it for. The priority date will go wherever you will go. Okay, I hope that makes it clear. Let's take a look at it again. So I join company B, I get a new offer from company C. Yeah, you can always take your I-140 priority date. Now, the right to keep getting 3-year H-1 extensions is based upon a surviving I-140. As long as the I-140 is not revoked, you can continue to get I-140, your H-1 extensions based upon the I-140. But if it is revoked, then you won't be able to get any further extensions and even transfer for the same. Let me take a step back. So let's say you've got 3 years. Okay, you joined employer B. 6 months later, you want to join employer C, but your old I-140 is revoked. You'll keep your priority date, but you will not be able to transfer your H-1. The most current thinking of the government is that we are not going to give you a transfer unless the I-140 is still in play. So the I-140 not being revoked is the key to your H-1 extensions. It is not key to your priority date. Priority date you will still keep. But if I were you, I would want to go with a company that starts my green card right away because it protects my right for further H-1 extensions. Star 5 if you have a question. Ram, if you're here, press star 5. Okay. Next one is Krishna, who says wife's visa status changed from H-4 to F-1 when she was in USA. Now she's in India. She wants to come back on H-4 and complete her master's. I don't see any problem with that. Check with the school. It looks okay to me. Will there be any problem for stamping or the port of entry? I don't think so. Personally, I don't see anything wrong with this situation. Just make sure if government asks you about your intention, etc., you're completely clear about telling them how things are. Don't try to conceal any facts. But going to school on H-4, I don't see it as a problem at all if you're finishing school. Okay. Star 5. Any questions on this? Follow up on this? Star 5. Press star 5 on your phone. Okay. Next one is Kiran007, who says, I have an approved I-140 from employer A. 9 to 12 years of your H-1B is going on. Planning to move to employer B. Will I get another 3 years? And the answer is you will not get an I-140, you'll not get an H-1 extension if your I-140 is revoked. Priority date, you'll be able to port. I just discussed this issue a second ago. So priority date, you'll be able to port as per the current USCIS thinking, even if the employer revokes the I-140, but you will not be able to extend your H-1 or transfer your H-1. Star 5 if there's a follow-up question on this, Kiran, or anybody has a follow-up question. Okay. Jane, US 99. Oh, there is, I guess, somebody with a follow-up question. Virginia, go ahead, please, Virginia.
Hi, Rajiv.
Haan ji, sir.
Yeah, sorry. Hi, Rajiv. This is Kiran.
Yes, Kiran.
I had this question. So you were saying if I-140 is revoked, I can't be able to get H-1B extension for 3 years. But if I get my H-1B extension before the I-140 is revoked and then my priority date is ported, that's fine, right?
Let me untangle that statement. You're right in theory, but let's untangle that. Once your H-1 is approved, government is not going to take it away even if the I-140 is revoked. So far, they've never done. Okay. I-140 priority date becomes your property upon the approval, and the employer's withdrawal of the I-140 doesn't affect that. So you need to start a new green card, both for completing your green card process with the old priority date, as well as having a way to further extend your H-1 if the old I-140 is revoked. Make sense?
Okay. So if I go to employer B and within the next 3 years, if the employer B should apply for my green card and I should at least have my labor approved or I-140 approved to get a new extension after the 3 years is done.
Your drop dead deadline for filing the labor cert is second year. After you join them, within second year, yeah, before the end of the second year, have them apply. Okay.
So I should be good if my H-1B, if I get a new H-1B and then I transfer to the new company.
Yes.
And they apply for green card and if I at least get a labor or I-140, I should be good.
Yes. The only risk in this situation is if for some reason government comes back and tries to revoke your H-1 for other reasons. For example, they mistook your job or they gave you a wrong, they didn't realize your degree was not related. Sometimes mistakenly approved H-1s can be revoked. But if it is not a mistakenly revoked H-1, which is a very small percentage, you should not have any other risk that I can see. Okay?
Yep.
Good luck.
Yep, thank you. Thanks, sir.
You're welcome. Okay, let's go on to the next one, which is Jane, US 97. I-140 is approved. Priority date is 2013. Project is going to complete. They're filing my third extension on approved I-140. How much time my extension will take in regular process? It's difficult to predict that, but many months as opposed to many weeks if you did it through premium processing. If my company is not ready to file premium, can I send check directly to DOL? Though you don't send check to the DOL, the check is sent to USCIS. And I believe it does need signatures of a requester. Who the requester is, I'm not sure if employee can be. I know that lawyers can be and the employer can be. And I do believe if the premium processing is for your convenience, it's legal for you to pay the fees for it. If you change your projects while an extension is pending, you'll have to file an amendment while the extension is still pending. Yeah, that can be done. So let's say you have an extension filed for project 1, but while it is still pending, you start on project 2. Before you start, file an amendment to project 2, even though extension is still pending. If while these two are pending, you get a third project, file another amendment. Each one is a separate case for case 3. And you can do that. You can daisy chain your amendments. Okay. So If I will not get new project and I have to go back to India, does my present company need to file a new H-1B after 2 years? You see, if your I-140 is approved, you can get your H-1 extension anytime. The problem here is quota, and because you can take something called the remainder option, I don't think you'll have a problem. Okay, so even if you had to go to India, you could come back on H-1. If I'm in India and the priority date can I become current, can I file for 85? You have to be physically in the United States. You can't do but if this situation becomes imminent that you have to go to India, please do a detailed consultation with your lawyers or with any lawyer. Make sure that you explain your situation and you understand what the rights and liabilities are. If the company revokes my I-140, another company try to file my H-1B and green card, they have to file a new H-1B lottery? Yeah, I think so, because if you are gone for, here's the situation. If your 6 years are over and your I-140 is revoked, you have no way of getting H-1 extension. So forget about the quota, you have no way of getting H-1 extension. If you're outside USA for 1 year, you've got 6 years of H-1 back, but now you're subject to the quota. Okay? Star 5, if there's a follow-up question on this. I hope I made myself clear. Oh, you are here, good. Let's make sure you understand what I just said. Okay, Canada, go ahead, Canada.
Hello, sir. I have good afternoon, Rajivji. I have similar situation.
Go ahead.
If I have 485 is applied in 2007, if I want to come back to the USA, since 2008 I'm in Canada, and my I-140 is approved and 485 is pending. Can I come back on H1? I need to go for the lottery, or how I can come back?
Well, first of all, 485 is not pending if your advance parole has expired. Has your advance parole expired or has it been renewed?
Advance parole is expired.
Well, if advance parole is expired, oh, hello? Sorry, I think I got disconnected. Give me a second.
Welcome to the Community Conference Center of Immigration.com, the law offices of Rajiv S. Khanna, PC. Please note, all calls are recorded and made available publicly, so you may want to conceal your identity and disguise the facts of your case. By participating in these calls, we are not establishing an attorney-client relationship. The accuracy of the information provided here cannot be guaranteed, and this is not a substitute for an in-depth consultation. Thank you for this opportunity to serve you. The conference is in presentation mode. Your line is muted. The conference will begin when the next party joins. You are now a host.
Hi guys.
Unmuted.
Sorry, I think the call got disconnected. Going back to what I was discussing, when you hear this recording, Canada, you will know that if your 485 is not supported by an advance parole and you're outside the United States, the 485 is considered to be abandoned. Look into that. That would leave you only one option to come back, which would be H-1. And if your H-1 was approved within the last H-1 was approved in the last 6 years, you will not be subject to the quota. You should be able to get a 3-year H-1. But if it was approved more than 3 years ago, in other words, your 3rd year approval falls outside the last 6 years, you will then have to go. I think you're back on the phone. Why don't you press star 5 again, Canada? Press star 5 again. Okay. Hello, can you hear me okay?
Yes, sir, I can hear it.
Yeah,
Thank you so much. Rajivji, but I got it approved, my visa stamp in passport by the embassy in Toronto until 2011 August. Means last 6 years till in until 2017.
Yes, that means you should be able to get a 3-year H-1 without having to go through the quota again. But one thing I'm concerned about is that your 485 is no longer in existence. When you come back, you would have to file the 485 again or start your green card all over again with a new employer and carry the priority date from the old employer. Okay.
But can I come on TN visa or no?
Are you a
I
Canadian
find
Are you a Canadian citizen?
yes, I'm Canadian citizen, sir. Yes, sir.
The only problem is if you have a green card applied for, getting a TN can be difficult.
Okay, sir.
Okay.
Yes, sir. Thank you so much, sir.
Oh, you're welcome. Good luck. Okay. Next question is, how can I find out how many I-140s have they filed, my company has filed, and how many have they revoked? I don't think you can. I don't think you can. And then asking me about the bigger companies, HCL, TCS, Infosys, what is my experience? Do they normally revoke I-140? I don't think I have any experience with that because we don't work with these companies and I don't know what they do with their I-140s. I'm not sure there is even a consistent practice. I've run into these occasionally during consultations while working with other clients, our own clients, but I don't think there's a consistent policy. And I'm certainly not able to comment about this definitively. Okay, so next question is from Digital Rain. They have a incorrect kind of green card for their 6-year-old child. This is what you should do. I looked at your situation. I was going to say, wait, we don't do asylum based cases, so I have no knowledge of this. But the way you should approach it is when you have a problem with an agency, the best thing to do is just contact your congressman's office. Instead of you trying to get this resolved, contact your congressman, tell them you have an immigration problem. Oh man, I just got disconnected again.
Welcome to the Community Conference Center of Immigration.com, the law offices of Rajiv S. Khanna, PC. Please note, all calls are recorded and made available publicly, so you may want to conceal your identity and disguise the facts of your case. By participating in these calls, we are not establishing an attorney-client relationship. The accuracy of the information provided here cannot be guaranteed, and this is not a substitute for an in-depth consultation. Thank you for this opportunity to serve you. The conference is in presentation mode. Your line is muted. The conference will begin when the next party joins. You are now a host.
Oh, sorry guys.
Line unmuted.
The line just keeps getting dropped. Okay, I'm back again. Now, so for you, the Digital Rain question, contact your congressman's office. Take their help in resolving the situation. By the way, guys, if I get disconnected again, I'll log back in. Next question is from, oh, by the way, anybody has any questions so far on what I've discussed, *5? I'll open the floor for new questions in a couple of minutes, just a few minutes more. Okay, next one is applying for citizenship and wanted to know how to fill the form. Look, we can't help you fill forms. If you look at the forms, it asks you who helped you fill this form and then they have to sign. So we can't help you fill forms, but I'll tell you this. Whenever you supply the government any information, it is usually better to err on the side of too much disclosure. So if I were you, I would make sure that I at least attach a statement explaining what happened. Because that visa denial and then it was in wrongful denial, might as well just make a statement about it, let them deal with it, just don't conceal anything. Okay, I don't think this is going to be a big problem, but attach a statement about what happened. How you fill the form, I can't comment, but attach a statement about what happened. *5, if there's a question about this, *5. Okay. Rohmal says, I'm currently full-time, reputed company, 17 months STEM OPT extension. I've also filed an H-1. I've applied for 7-month extension. Can I travel? Well, here is the problem. If you travel before your H-1 change of status is approved, your change of status is deemed abandoned. They'll approve the H-1, but then to activate the H-1, you'll have to go outside USA for a visa stamping or apply for a change of status, which is sort of like filing the H-1 all over again. So you cannot travel until the H-1 is approved. After the H-1 is approved, can you travel? I believe there are some restrictions on that 7-month extension. Make sure you check with your DSO and even USCIS customer service before you make plans. Okay, but under no event can you travel before H-1 approval. Uh, if you have any questions, star 5. Any follow-up questions, star 5. Okay, last question is from Viniji. I see you're on the phone, and your question, and you had sent me an email, and I had said there's no need for a one-on-one consultation. Let me see if I can straighten this out for you. So the issue is we've not filed the last 3 tax returns. What should we do? Okay, and the answer is quite definitely what you should do is file your tax returns at the earliest, because without that, getting your 864 for your wife would be a problem. So I also believe, Viniji, you can talk with your CPA about this. But I think for the purposes of filing the tax return, you could actually just get a tax ID number for her instead of a social security number. Double check on that. Okay? That way, you can actually file the tax returns jointly. If you have a question on this, press star 5. Yeah, Viniji, go ahead. I can hear you.
Hello, sir. This is Vineet Neji. So, sir, my question is, when I went to the InfoPass, the officer there was telling me the only issue with you right now is your your tax has not been filed since 2014, and they just need the documents on that. That's the issue he said me, and he said as you're military active duty, you will not be having much problem. But the problem on my end, sir, is how should I proceed right now? Should I just file my tax, go to
Yeah,
HR block, or
that's what I just answered. I think you should go to a CPA instead of HR block. Go to a CPA,
Mhm.
and maybe they can apply for a tax ID, not a social security number, a tax ID for your wife, and help you
Yes, sir.
file jointly. Were you married in 2014?
Sir, say it again, sir.
Were you married in 2014?
Yes, sir. Yes, sir. I married in April 2014, sir.
Okay, so talk with the CPA and see if you can get the tax returns filed. With those filed, you should be okay, and I think that's the best solution.
All right, sir. And sir, one more question was I concurrently filed her I-765 and I-131
Sure.
advance parole documents. So even for that, they told that everything is on hold because of this. They said we cannot process your document because it's been now 3 months,
Okay.
and they're telling me that they're holding everything because of that.
Well, normally they do approve EADs, etc., without even if the document is incomplete. I don't know what exactly is the issue there, but step one would be, of course, to get the tax returns taken care of. That's what I think. Okay.
All right, sir.
All
All right,
right.
sir. Sounds good, sir. Yeah.
Good luck, sir.
Thank you very much, Rajiji.
You're
Yeah.
welcome.
Thank you very much.
You're welcome. Okay, folks, I'm done with posted questions. Anybody has any question, new, old, doesn't matter, press star 5. Anybody has any question, press star 5. No questions? No new questions? Very good. Okay, very good. We'll see you again, folks, in 2 weeks. As always, it's great fun talking with you, and I thank you for the opportunity to talk with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.